Trying to sell real estate out of a deceased probate estate. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 682. SCAO for State Court Administrative Office, PC for Probate Court, Form 682. This form is readily obtainable. We are happy to give it to you free of charge. As with all SCAO forms, they are created by various statutes or court rules. As you can see from the floating yellow arrow, MCL 700.3415, MCL 700.3505, and MCL 700.3704. These are the statutes that give rise to this particular form. And this particular form is an order, which means that there would have been a petition filed to allow for the entry of an order. A petition is filed, it's filed with the court, scheduled for hearing, notice is given, all the interested parties are given notice, there's a court hearing, and then the court enters an order. Now, with all of these SCAO forms and probate processes, we strongly urge you to be working with a skilled, competent probate lawyer to be able to guide you through the process, to show you how to navigate through this complicated process. And generally, you're using this form in a deceased administration when there are restrictions on the letters of authority. Because if there are no restrictions, you may simply be interested in selling the real estate without seeking a court order, although you have the right to do so. But generally, this petition order process in a deceased probate estate is done when there already are restrictions on your letters of authority that prohibit you from conveying, selling, encumbering, and so on real estate without a separate court order. Now, as you can see also from the red rectangle, it says decedent's estate. There is a similar process that is done in a conservatorship context. This is not the form, it's not the court order that's used though. This is only used in a deceased probate estate administration. Let's work our way through the form. Top left corner is the county upon which the probate exists. Top right corner is the case number. Again, the estate of is the name of the decedent, pretty intuitive here. The name, the date of the hearing, the judge who made the adjudication. Section 2 is the name of the personal representative, and they had petitioned the court seeking the approval of the sale of real estate. Here are the findings of the court. So again, these findings don't have little check boxes because it is assumed that notice of hearing was given to or waived by all the interested persons. The reason it's assumed is the court wouldn't adjudicate the right to sell the real estate if the requirements relative to notice to all the interested persons within a probate petition for sale of real estate weren't already given or waived by the interested persons. Section 4 says that it's in the best interest of the estate to sell or otherwise dispose of the real estate. So the court has to make a determination that it's in the best interest. So there are times that the court may not find it in the best interest. Maybe the sale price is too low. Maybe it's being sold to a family member and the other family members are objecting because the value could be quite a bit higher. Or maybe it's an inside transaction among related people or entities. So again, this is an example where the court may not find it to be in the best interest. Or maybe one of the family members wants to keep the property and pay off the remainder of the family. So again, there are reasons that the court may not find it in the best interest. I'm just giving you some ideas or examples of times that the court may find that it's not in the best interest. Section 5 is a bit confusing for some people and also a huge barrier for many personal representatives when a court enters an order for sale. Generally here, the court is making a determination that there is a need for a bond. And a bond is a guarantee of performance, a surety bond. And if the court imposes a bond, it's usually equal to the net proceeds of the sale of the real estate. So for example, if the house is being sold for $100,000 and that will be the net amount coming into the estate, the court may impose a bond for $100,000. Now, getting a bond is not always easy. Generally, they want to make sure you have a lawyer. Many bonding companies require it as a prerequisite to getting a bond. You also may have to have good credit and no criminal history, no recent bankruptcies, and so on. Because they want to make sure that if they provide a guarantee of performance, that the personal representative is going to appropriately perform their role. So again, if the bond is required, you'll see that Section 5 checked. Section 6 is the legal description of the real estate. Remember, when you're conveying real estate and selling it, you're really not selling the address, you're selling the legal description, the land and everything above or below. So the legal description is relevant here. So you want to use the legal description as set forth in maybe on the prior deed or through a title company to make sure you have done it accurately. And again, with all of these processes, we strongly urge you to be working with a skilled, competent probate lawyer who knows how to navigate through these processes, because it is confusing. It's not intuitive or easy to do. The lower section is the order section, and it's a little bit of a repeat from above, but this is now the part in which the court is entering an order. And in this case, 7, the sale of the real estate. 2, which is to whom the party, the estate is selling, would be reflected there. And the amount is reflected there, and the payable on the terms as set forth in the petition. So again, in the original petition for sale of real estate, within the deceased estate, typically you're including the a copy of the purchase agreement and other related documents. So the terms are going to be reflected. And here in Section 7, the court can say that the terms as reflected in the purchase agreement are approved. Section 8 is if there's a requirement for a written appraisal. And an appraisal is a valuation of the real estate done by a professional appraiser, and the court may require that as a condition to the sale to make sure that you're selling it for the correct amount, and as we set forth in the findings on number 4, that it's in the best interest of the estate. So for example, if you sell for 100 and the appraisal comes in at 200, the court may very well find that it's not in the best interest of the estate. Section 9 is if the court just simply denies the request as set forth in the original petition. The court has a checkbox to do so. There's also times that we see the court entering other conditions, not just the ones that are set forth here, and that may be included within a court order. But the SCAO form doesn't have an extra space for that. The judge's signature, which is the entry of the court order and the date, and then if there's an attorney involved, the attorney would be there. Now, it's really important that this order gets filled out correctly, because often this court order gets recorded in the chain of title at the Register of Deeds. So if it's not filled out correctly, then it may be unable to be recorded at the Register of Deeds. It could also disrupt a title insurance company's willingness to insure the transaction, and it may affect the buyer's interest and willingness to buy. So it's really important that you complete this correctly. You may need a certified copy of it for some counties to be able to record it. And then this order is giving the authority for the estate, for the personal representative, for the right to sell the property to the buyer as reflected. Now, often this order may get entered and then all of a sudden the buyer fails for some reason, can't perform, can't close, and you got a new buyer that shows up. Yes, each time got to go back and get authority unless the order gives great flexibility for the property to be sold to other buyers. So this is a very particular order. It's for the single transaction as reflected in the petition. The buyer is specific, the sale price and the terms are specific. So again, you have to really think this through when you go through this process, because it's awfully frustrating to file a petition, wait for the court hearing, go through all of the steps of serving, and then the buyer can't perform, and then you have to do it all over again. It can be really frustrating, and that's why, again, working with a competent probate lawyer through this process will just make your life a lot easier. At the Probate Pro, we are passionate about everything probate. If you have questions regarding the order, regarding the sale of real estate, or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.